Weed smokers rejoice around the country today because we know most of them are no harm to anybody, maybe to themselves in their lungs, but that's their choice. But they are not dangerous, and the key here is the government doesn't get to determine that anymore going forward, do they? Take it away.
No, it was phenomenal. They got filleted, they being the United States government. Before we dive into this, I will say this was a narrow decision as applied to Mr. Hemani. However, just know that the government, they did say at the end of this that this decision does not affect those who are, or rulings with people are presently intoxicated, so the government can still come after you for that, or if the government can create evidence of your intoxication and how you become a danger to yourself or others, or any new laws that Congress may pass down the road. But with that said, this was a slam dunk, 9-0. Even Ketanji realized that the government was so far out of whack here because literally the way the law had been handled for the last 30, 40 years, if someone had one marijuana cigarette, they were banned for life. Doesn't matter if they did like Hemani every other day or smoke every day. One and done, and that's how vague that law was. And finally, the Supreme Court took that case up and destroyed it.
Now, I've seen some comments on a couple videos that I put out regarding the narrow applies to Hemani. Would you care to enlighten listeners and viewers as to what that means?
Yeah, it means as it was applied to this person in this case, they cannot prohibit him forever because he smoked a couple times a week. The government never proved like you said, it never proved how effective he was or if he was ever carrying a firearm while, under the influence of marijuana. That's what it means by narrow. It doesn't, forgive everything everybody's ever done. If you have an attorney and you're in one of those scenarios, this could be something you might want to talk to your attorney about. And maybe or maybe not, there is an avenue for you using the Hemani case as precedent. But going forward, things are definitely going to be different.
Yeah, let's talk 4473 real quick while we're on that subject of going forward, because no sooner than I had the video going out, the 4473 change proposals were already coming down the pike. Now, I responded to one of your tweets, Jared. It just needs to go away. They're rephrasing this, or are they going to do the right thing and just wipe it off that 4473, which is exactly what should happen in my estimation?
It'll probably be rephrased because, I don't know this, but my assumption would be it's easier to prove that, say, someone who takes heroin once or twice a week is addicted because it's much more of an addicting narcotic. So they'll probably reword it somehow. Half this country has legalized marijuana in one way or another. In fact, that's one of the questions I have for the director, who I will be sitting down with on Tuesday. You heard that here first. Good
deal. Well, Hunter Biden came up as well, because this was the same deal that Hunter Biden was prosecuted under. Although I'm going to tell you this right up front, there's a distinct difference here, because it could easily be shown that he was, in fact, an addict. And with this narrow decision in Hemani, that's some of the distinction that you were just referring to, is it doesn't mean that everybody that smokes weed is free and clear. If you are proven dangerous, the government just can't assume you're dangerous because you take a hit off a pipe or a vape or a doob, whatever it is. That now is gone by the wayside. But if they can prove, in fact, that you are dangerous as a result, now I think we could have made that case with Hunter Biden as an addict, but nonetheless, we are where we are today. I have some theories about this. Greg, how much time do I have?
30.
We got 30 seconds. Jared, I'm going to take us to the break with this. When we come back, I want to ask you a couple questions about a theory that I have. And as the more I reason through this, brother, the harder it is for me to not believe myself. I don't know if I'm articulating that properly, but as I look at this, I think there's got to be a reason the government moved for cert on a Fifth Circuit case when they know how strong the Fifth Circuit is in their rulings. They know how well they were written, yet the government went forward anyway, trying to use the habitual drunkard thing. Really? Seriously? They had to know. When we come back, we'll go a little bit deeper